The U.S. Court of Appeal for the Fourth Circuit has a very different point of view from the Second Circuit when it comes to the Trump administration's rule interpreting public charge. We'll tell you just how stark the contract is. Stay tuned. My name is William Kovach, and I am a trained immigration lawyer. I've often been disappointed in the way immigration issues are talked about in the media. Although it's not always their fault, immigration law can be a very complex subject touching upon constitutional issues as well as personal political points of view. My goal is to explain immigration law to you, concentrating on looking at judicial opinions and executive actions in order to explain how immigration law can have an impact on our community and on our country. I hope that you'll join me as we try to make sense of immigration law and how it may affect the average person. This is the third in a series of 3 videos concerning the Trump administration's policy change when it comes to defining what a public charge is. Now, just as quick background, the U.S. Immigration and Nationality Act, or the INA, prevents aliens who are likely to become a public charge from immigrating to the United States or becoming a permanent resident, or in the vernacular, getting a green card. The basic idea is that the United States does not want a person to come and live here if that person is just coming to live here and is going to be dependent on the United States for their livelihood. The argument is one of degree. Does the public charge rule mean that we don't want an immigrant to benefit from any government program, even if their use of that program may be temporary? Or are we more worried about those people who just cannot take care of themselves on their own? People who have something wrong with them, or maybe they can't rely on themselves or don't have any family as their backup plan. So we've already discussed a case from the Second Circuit. That was the subject of the second of these videos, and we'll have a link to that video in the description box below. Now, the Second Circuit clearly stated that Congress's concern is with those people who were just unable to take care of themselves, and not with those people who may need a little occasional help from the government. And how did the Second Circuit get there? Well, remember, Congress writes the laws, and the executive branch will administer a program. When they do so, they occasionally need to interpret the written law. And we have rules on how the executive branch is able to interpret the law that's been passed by Congress. Those rules come from a Supreme Court case which was called Chevron, and that Chevron analysis involves a number of steps. The first step in the Chevron analysis is to look to the actual words as used by Congress. If those words are clear on their face, then we're done. There's no room for any interpretation. But if the words that Congress used are ambiguous, meaning they can have more than one meaning, or if Congress specifically left a question for the executive branch to answer, well, then the executive branch has the power and authority to interpret the law as written by Congress. But that interpretation still has to be permissible. And in the second step of the Chevron analysis, we're looking at whether an interpretation is permissible. And one way to tell if an interpretation is permissible or not is to see if it conflicts with Congress's intent when they passed the law. But even if those words are ambiguous, and even if the executive branch has interpreted those words before, that doesn't lock the executive branch into always using that interpretation. The executive branch could have a change of policy. The thing is that if the executive branch does so, the new interpretation must also be permissible, and the executive branch must offer a reasoned explanation for the change. So, with all that as background, let's dive into the Fourth Circuit's decision, which, I remind you, was issued one day after the Second Circuit issued its opinion. This is from the Fourth Circuit Court of Appeals, Casa de Maryland versus Donald Trump. Okay, so let's remember the U.S. Courts of Appeals are divided into 13 circuits. Of those circuits, 12 are determined by region, meaning a number of states in a region are in a single circuit. The Fourth Circuit hears cases that originate from Maryland, Virginia, North Carolina, and South Carolina. Now, if you're thinking that the District of Columbia is in there somewhere, the District of Columbia gets its own circuit court, and that's just because of the sheer number of administrative agencies in that city, and so it has its own circuit. The Immigration and Nationality Act, INA, says that any alien who is likely at any time to become a public charge is inadmissible. Congress has included some version of a public charge provision in the nation's immigration laws since 1882, but it has never defined the term, instead leaving its implementation to the executive branch. Okay, so from the language that's used here, we can already see that there is a clear difference between the way the Second Circuit, in the case of New York versus Department of Homeland Security, and the way the Fourth Circuit looked at this issue. You may recall that the Second Circuit went through the entire history of public charge as it's appeared in immigration law in painstaking detail. It came to the conclusion that public charge, as used by Congress, can have only one meaning, and that's because the executive branch has always given it that same meaning in immigration law. And therefore, when Congress issued new versions of an immigration statute, and it included the term public charge over and over again, it was aware of how the executive branch had interpreted public charge, and therefore was adopting that interpretation. The Fourth Circuit here is saying, no, we don't buy that argument. Congress has never defined the words public charge, and therefore they've always left it up to the executive branch to define it. Recently, the Department of Homeland Security sought via rulemaking to define public charge as an alien who was likely to receive certain public benefits, including many cash and non-cash benefits, for more than 12 months in the aggregate over any 36-month period. The district court here enjoined the rule nationwide. So a little more background. When the Department of Homeland Security issued this new rule, a number of parties filed lawsuits in the federal court system, and the trial level court in the federal system is the U.S. District Court. This particular lawsuit was filed in the U.S. District Court for the District of Maryland. Now that court issued a preliminary injunction. So a preliminary injunction is basically an order that a court issues before it has a chance to hold a trial. And by doing so, the court is basically saying, we want to keep the status quo. We want to keep things the way they are until we can have our hearing. Now, a preliminary injunction is typically a very difficult remedy to get. There are a number of factors that the courts will analyze in whether to issue a preliminary injunction. One of those factors is likelihood of success on the merits. And likelihood of success on the merits is one of the main things we're going to address in this video. Also notice that the trial court issued a preliminary injunction that prevented the Trump administration from implementing this rule on a nationwide basis. And that's a pretty rare thing for the courts to do. It wasn't just effective in this state of Maryland or effective just towards these particular plaintiffs. A preliminary injunction usually covers only the specific region that court is responsible for. In this case, statutory interpretation meets separation of powers. To invalidate the rule would visit palpable harm upon the Constitution's structure and the circumscribed function of the federal courts that document prescribes. Striking the rule would also entail the disregard of the plain text of a duly enacted statute, all in an area where the Constitution commands special judicial deference to the political branches in light of the intricacies and sensitivities inherent in immigration policy. Wow, this court is making it out to be a real constitutional crisis if they struck down the Trump administration's rule. Now, if you've been following the series, you know that different circuits have very different personalities and different approaches, particularly when it comes to immigration law. When we talked about asylum law, for example, we looked at the Fifth Circuit, which is based in Texas. And the Fifth Circuit is very conservative, very deferential to the executive branch. Whereas when we looked at opinions that came from the Third Circuit and the Second Circuit, they were less deferential. And here we see that the Fourth Circuit is acting much like the Fifth Circuit. It's being very deferential to the executive branch when it comes to immigration law. The above does not mean that the plaintiff's view of the public charge provision is definitely wrong, nor does it mean that the government's view of the public charge provision is definitely right. Rather, the public charge provision has led for almost a century and a half a varied life, with different administrations advancing varied interpretations of the provision, depending on the needs and wishes of the nation at the particular point in time. To be sure, the public charge provision ties alien admissibility to prospective alien self-sufficiency. But within that broad framework, Congress has charged the executive with defining and implementing what can best be described as purposefully elusive and ambiguous term. Congress has assiduously resisted giving the term the kind of fixed and definite meaning that the plaintiffs to this lawsuit seek. We are reluctant to step in and perform that task ourselves, thus transferring primacy in national immigration policy from the democratically accountable branches where it has long been thought to reside. So again, we're putting an emphasis on how the Fourth Circuit disagrees with the analysis of the Second Circuit. The Fourth Circuit is saying that the term public charge is ambiguous, and it always has been. It has been left ambiguous in order to let the executive branch craft its policy based on the needs of the times. But what is clear is that the rule has always tied whether an alien can come and live into the United States on whether that alien is self-sufficient. The huge difference between the Second and Fourth Circuits is over what self-sufficiency means. Does it mean that you get no help from the government at all, or does it mean that you can get a little bit of help so long as that's only to get you over a hump or address a temporary need, but you just can't rely on the government permanently. There is a further and daunting obstacle in invalidating the rule. In the course of prolonged litigation in the lower federal courts, the Second and Seventh Circuits declined to stay injunctions issued by trial courts precluding enforcement of the rule. The Supreme Court thereupon granted the government's emergency request to stay the preliminary injunctions, an action which would have been improbable, if not impossible, had the government, as the stay applicant, not made a strong showing that it was likely to succeed on the merits. We may, of course, have the technical authority to hold that, notwithstanding the Supreme Court's view, the plaintiffs are likely, after all, to succeed on the merits of their challenge, but every maxim of prudence suggests that we should decline to take the aggressive step of ruling that the plaintiffs here are in fact likely to succeed on the merits right upon the heels of the Supreme Court's stay order, necessarily concluding that they were unlikely to do so. Such a step would require powerful evidence that the Supreme Court's stay was erroneously issued. Such evidence is absent here. Okay, so here's a little more background. Several district courts issued preliminary injunctions that prevented the Trump administration from enforcing its rule on what a public charge is. That is, those courts did not allow the government to apply its rule until it could hold a trial on the issue. The Trump administration obviously didn't like the outcome, so they decided to go up another ladder in the hierarchy of the courts. The next ladder would be the courts of appeal. Now, in this instance, there were cases that were filed in the Seventh Circuit, which is the circuit that includes Chicago, and the Second Circuit, which is the circuit that includes New York. and the government was looking for a stay. A stay is just a court order that prevents the preliminary injunction from taking effect. Neither the Second nor the Seventh Circuit gave the government the stay that it wanted. So the Trump administration went up one more level in the federal system. It went to the highest court in the federal system, and that is the Supreme Court. And the Supreme Court, by a vote of 5-4, issued the stay. So now, let's take a look at the text of the order that came from the Supreme Court. And here's the Supreme Court's order. You'll see that it came from the case from the Second Circuit, the Department of Homeland Security versus New York. And the stay was issued on January 27th, 2020. The application for stay presented to Justice Ginsburg and by her referred to the court is granted. And the District Court's October 11, 2019 orders granting a preliminary injunction are stayed pending the disposition of the government's appeal in the United States Court of Appeals for the Second Circuit and the disposition of the government's petition for a writ of certiorari if such writ is timely sought. Should the petition for a writ of certiorari be denied, this stay shall terminate automatically. In the event the petition for a writ of certiorari is granted, the stay shall terminate upon the sending down of the judgment of this court. Justices Ginsburg, Breyer, Sotomayor, and Kagan dissented. So all the Supreme Court's order does is say that it's giving the government the stay. The court doesn't go into details of reasons why. It doesn't go through the requirements of obtaining an injunction for preliminary relief. It just says, we're issuing the stay. And here's the thing. That's common. The court's issuing the stay doesn't necessarily have to write a long opinion justifying its action. And that's because it's not supposed to be the end of the case. Yes, we've got this legal requirement that you need to address the likelihood of success on the merits. But this is before the trial court can have a chance to collect testimony, hear evidence, hear arguments, and they can't say with 100% accuracy that this party or that party is going to win the case. The requirement is really just supposed to be, do you have a plausible, decent chance of winning the legal argument? And is your chance high enough that it justifies having the courts step in now? So very often, the Supreme Court will issue these types of short opinions when it grants something like a stay, something that says very little. My problem is that the Fourth Circuit is taking this order from the Supreme Court, which says nothing, and it's turning it into this strong statement that the party challenging the government's interpretation is going to lose. The Supreme Court didn't say that. Now, I'm going to tell you, I used to work as a law clerk for a judge on a court of appeal, and I would see other judges doing what it is the Fourth Circuit is doing here, and that is by taking some action from the Supreme Court, reading a much broader effect of that action than the action actually has. That is, they're taking this very limited action and extrapolating a much broader rule than what the words that the Supreme Court used warrants. It's like reading the tea leaves, if you will. They're trying to predict what the Supreme Court is going to do before the Supreme Court actually does it. And they're letting that be their guide instead of just addressing the legal issue that's before them right now in this case. We begin with a brief overview of the public charge provision's long history. Though, as discussed below, the provision has been amended numerous times over the past 138 years, its motivating purpose has remained the same: to prevent the admission of aliens who, to one degree or another, would depend on the public for their support and care. So now the court is going to go on and address the term public charge as it's used in the statute over history. Now, we've already gone over all of this in our second video, so we're just going to skip ahead. Plaintiffs claim that the DHS rule violates both the APA and the Fifth Amendment. Specifically, They assert that the rule is not in accordance with law under Section 706 of APA because 1. The term public charge means primarily dependent on the government for subsistence. 2. This meaning is unambiguous. And 3. As a result, DHS lacks the statutory authority to reinterpret public charge admissibility in a way that is contrary to that definition. They also state that the rule is arbitrary and capricious and violates the Due Process Clause and the Equal Protection component of the Fifth Amendment. This is a summary of the plaintiff's arguments. They have 3 arguments and they're all in the alternative, and that's because those 3 arguments can't all be simultaneously correct. These are all arguments that require the Chevron analysis that we've spoke of before, and that means that we're going through that 2-step process to determine if the interpretation that the Trump administration adopted was permissible. Step 1 of that analysis looks to the words of the statute themselves. Are those words unambiguous, meaning there's only one meaning those words can have? And the plaintiff's first argument is that the words public charge, as used in the statute, can only have one meaning, and that is primarily dependent on the government for subsistence. If the words public charge can only have that one meaning, then there's no room for any interpretation at all, and the rule that Congress adopted applies. Step 2 of the Chevron analysis says that if the words are ambiguous, that is, can they have more than one meaning, or if Congress specifically left the issue up for the executive branch to decide, is the interpretation that the executive branch adopted permissible? And to determine this, we often look to what congressional intent was in passing this legislation. Did Congress adopt reports on the bills before it was passed? Is there an explanation of the bill and its purpose? Did the report go line by line through the text that Congress used and explain why it was using the language it did? Sometimes we look to testimony before a committee hearing. Sometimes we look to the bigger context of the legislation. Was there a big political fight between the branches? Was the language that was used by Congress a compromise? And we could also be looking at constitutional issues in this step. Would the interpretation that was adopted by the executive branch violate the Constitution in some way? Maybe we're looking at the Due Process Clause. Maybe we're looking at the Equal Protection Clause. Courts will construe a statute, meaning it will give the statute a meaning that does not conflict with the Constitution. But that also means that the executive branch must construe the statute in such a way that it doesn't conflict with the Constitution. Also, the executive branch can't take actions on its own that conflicts with the Constitution. But even if the interpretation was permissible under the second step of the Chevron analysis, there's still one more requirement. If the interpretation is a change in policy, then the executive branch must acknowledge that, and it needs to explain why it's making this change. If the government doesn't give a reasoned explanation, then the interpretation can be struck down. And in order to analyze that, we would look at the Federal Register, where the executive branch would publish its policy change, and it would give its reasons for that change. So what did the government say in that publication? And does that explanation make sense when it's placed in its full context? Turning to the merits, the district court held that CASA was likely to succeed on its APA claim that the rule was not in accordance with law. In reaching this decision, it applied the familiar 2-step Chevron framework for analyzing agency interpretations of statutory provisions. As part of this analysis, the district court considered various pieces of evidence regarding the meaning of the term public charge from the time it first appeared in law in 1882 to various legislative, executive, and judicial attempts to change or to interpret the provision in the many decades since. According to the court, this evidence taken together established that Congress has spoken directly to the issue here and precluded DHS definition of public charge such that the rule failed at the first step of the Chevron analysis, or, alternatively, that the public charge rule fails at Chevron step 2 as an impermissible reading of the statute. All right, so remember, we're in the U.S. Court of Appeals, and that's the appellate level. The decision has already been made by the trial court. That trial court was the U.S. District Court for the District of Maryland. And the Fourth Circuit here has summarized the holding of the district court. The trial court, we see, went through that Chevron analysis that we just spoke about. And it came out with the conclusion that there could only be one meaning to the words public charge, and that therefore the executive branch was not even permitted to adopt an interpretation. So if you saw our video on the case of New York versus Department of Homeland Security, that was the second video in this series, you saw that the Second Circuit, which is another court of appeal, also found that the words public charge were unambiguous and that the executive branch had no authority to adopt any interpretation of those words. And as I mentioned, I find it very interesting that the Second Circuit, a sister circuit court to the Fourth Circuit, that is, they're on the same level, that they came out with their decision, which is diametrically opposed to the Fourth Circuit, and it came out one day before this decision. So now we have another issue, and we have a number of side issues in this case. Here, the issue is whether the Casa de Maryland, which is one of the plaintiffs, even has standing to bring this action. And for the sake of brevity, we're going to skip that. We're just going to concentrate on the issue of how the Fourth Circuit is defining public charge. The INA states that any alien who the executive determines is likely at any time to become a public charge is inadmissible. This case turns on the meaning of public charge and whether the rule is based on a permissible construction of that term. As always, we start with the text. While some version of a public charge provision has been a part of federal immigration law since 1882, Congress has never defined the term. When phrases used in a statute are undefined, we look to the ordinary meaning of the term at the time Congress enacted the statute. What we see here is the plaintiffs are already starting out in a hole. The Fourth Circuit just said that Congress never defined what it meant by public charge. The ordinary meaning of public charge in 1952 was one who produces a money charge upon or expense to the public for care and support. So another thing to point out here is that many times, because we're talking about looking at the specific language that Congress used when it wrote the law, the lawyers and the courts will break out their dictionaries and they're going to look at what the ordinary meaning of those words is. And that is what the Fourth Circuit is referring to here. In fact, the Fourth Circuit is going so far as to find a dictionary published in 1951 so it can prove what the words public charge meant in 1952, as opposed to what it means today or what it may have meant back in 1882. Arthur Cook, in Immigration Laws of the United States, published in 1929, defined public charge as a person who needs any maintenance or financial assistance rendered from public funds or funds secured by taxation. What's relevant here is that the court is citing a book by Arthur Cook on U.S. immigration law from 1929 that the court is using in order to find what the definition of public charge was as used in that book. Their point is just to show that different sources had different definitions. And many times when we're looking at this type of an issue, trying to define a term, we'll use secondary sources. I mentioned dictionaries before. We might also use restatements of the law or a compilation of the law written by a famous, renowned legal author. And charge in this context meant a cost or expense. The district court, though, took up a different starting point. It looked to the meaning of charge in 1882, the first year a public charge provision was included in federal law. The court, relying mostly on two contemporary dictionaries, reasoned that charge meant a person or thing, or entrusted to the care, custody, or management of another. So, public charge, therefore, meant a person who the government has taken care, custody, or management of. Put otherwise, the district court said a public charge in 1882 meant something akin to a pauper, and it has meant the same thing ever since. You can already see here that the Fourth Circuit is setting up a sort of dueling dictionaries, or dueling definitions, and this is intentional in order to create confusion about the exact meaning of the term as used in the statute. And it's meant to build up the argument that the term is not clear on its face, but subject to different meanings. For starters, we strongly doubt that public charge has been consistently understood as synonymous with pauper. Indeed, from 1891 to 1990, Congress listed both public charge and pauper in the same statutory provision, and it is a fundamental canon of statutory interpretation that courts, whenever possible, should give independent statutory terms independent meaning. And here we go. The court's conclusion is that the words are not clearly defined. The court is looking at other sources in order to show that these terms have different meanings in the different sources, right? Now, you may recall when we had that second video on the Second Circuit decision, I told you my personal opinion, and that is that the term public charge is not unambiguous, that it needs definition, and that what the Second Circuit was really doing was more towards the second step in the Chevron analysis, and that's looking at the interpretation as adopted by the executive branch and determining whether it was permissible by looking at legislative history, prior versions of the law, looking at committee reports, looking at hearings, because I believe much of what the plaintiffs are arguing really goes to that second step and not really to the first step. In all events, the present structure of the INA confirms that public charge should be given its broad ordinary meaning as understood when the INA was enacted in 1952. Most importantly, the INA is structured to give the executive discretion to administer the public charge provision, which undermines the idea that the term has the sort of fixed and circumscribed definition ascribed to it by the district court. As noted, the INA does not define the term public charge, let alone contain anything like a primarily dependent standard within its text. Rather, it expressly entrusts the decision of who is a public charge to the opinion of the DHS secretary. Ordinarily, this sort of language indicates that the executive has extensive discretion over the relevant determination, especially here where Congress has baked discretion into the statutory scheme many times over. For instance, the INA lays out 5 non-exclusive factors that executive officials should look to when making public charge determinations, but also states that such factors should be considered at a minimum. This reinforces the point that it is the executive who has the ultimate discretion under the INA over who is a public charge and what is most relevant to that decision. In other words, nothing about these broad grants of power suggests that the term must be read more narrowly than its ordinary meaning. What the court is talking about here is this trend in legislation that started around the time of the Great Depression. And what would happen, Congress would create these grant programs, and it would leave it up to the executive branch to administer those programs. And the executive branch would then go hire professionals who would be the expert in this particular area of law or this particular policy, and those experts would administer the programs. So when making these grand, big programs, Congress would pass these statutes that had broad principles. And it could be a broad principle like what's involved in this lawsuit. That we don't want people to immigrate to the United States who are likely to become public charges, because we don't want them to come here and then use up all of our resources. And then once we had that grand policy, Congress would leave it up to the executive branch to fill out all the specifics and the details when it came to implementing the new program. And this trend is why the executive branch expanded so much in the 20th century, and it saw a fundamental shift in which of the branches of government was more powerful. As the executive branch was given more and more functions, it grew in size and power. And now the argument is that if Congress doesn't like the way it is or what the executive branch is doing, Congress holds the ultimate power. It can pass a new law, and that new law will be supreme, taking precedence over any executive action. Surrounding sections of the INA point in the same direction. Take the sponsorship and affidavit scheme that Congress designed to work in conjunction with the public charge provision. Under this scheme, a necessary condition for avoiding a public charge designation, many aliens must obtain sponsors, be it family members or employer, who will provide a legally enforceable affidavit of support on their behalf. An alien's sponsor must pledge to maintain the sponsored alien at an annual income that is not less than 125% of the federal poverty line, and reimburse the relevant government agency if the alien uses any means-tested public benefit. Failing to obtain a sponsor renders a covered alien automatically inadmissible as a public charge, no matter his personal financial circumstances. This sponsor and affidavit scheme affirms that public charge should be given its ordinary meaning. The content of what is required by the affidavit, including both its minimum income and reimbursement guarantees, coupled with the fact that it is required for many aliens, underscores that the public charge provision is naturally read as extending beyond only those who may become primarily dependent on public support. Indeed, adopting plaintiff's definition, as the district court did, would create an odd gap between the public charge provision and the sponsorship and affidavit system designed to accompany it. The clear object and effect of the sponsorship scheme is to guarantee that aliens will be self-sufficient and not impose any meaningful burden on the public. But on plaintiff's view, the same Congress that fashioned this system, as well as every Congress since 1882, also believed that the public charge provision only apply, and could only apply, to aliens likely to become primarily dependent on public support. This does not fit. That is, it does not make sense that Congress designed a sponsorship scheme focused on self-reliance as a necessary part of complying with a statutory provision concerned exclusively with primary dependence. It would be like an amusement park having parents sign a form attesting that their kids are 5 feet tall in order for them to get on rides that only require persons to be 3 feet. Giving public charge its ordinary meaning, however, avoids this sort of incongruity and allows both provisions to work together. Okay, that was a weird analogy. I think somebody's law clerk got a little bored that day and tried to throw in something that he or she thought might be relatable to the common person. But the point that the court is making is that the way the statute is set up actually belies this argument that the term public charge has to mean someone primarily dependent on the government for subsistence. And one of the reasons is this sponsorship requirement. All aliens who are coming to the United States as immigrants based on family ties have to submit an affidavit of support from a sponsor. And that sponsor, through the affidavit of support, is promising the government that he or she is going to support financially this alien until they're ready to get on their feet. Usually that is for a period of 40 quarters. That is, the alien needs to work for 40 quarters or 10 years. And that is the minimum amount of work that a person has to do in order to become eligible for certain Social Security benefits. So These numbers aren't coming from out of nowhere. It's supposed to work as a harmonized system. The point is that if the statute is taking into consideration factors other than government subsistence in determining whether someone is likely to be a public charge, then the whole argument that the words have to mean this one thing doesn't have strength, doesn't hold water. What is more, related immigration statutes support this reading of the public charge provision. When Congress last amended the public charge provision, it also passed the Personal Responsibility and Work Opportunity Act of 1996. The act barred most aliens from receiving many cash and non-cash benefits for 5 to 10 years, and it established that an alien's income would include his sponsors for the purpose of qualifying for other aid. Congress passed these provisions in order to assure that aliens be self-reliant and not burden the public benefits system. Giving public charge its ordinary meaning brings that provision into line with this surrounding program and its stated goal that aliens within the nation's border not depend on public resources to meet their needs. Adopting plaintiffs' proposed definition, on the other hand, would give the public charge provision a notably more limited scope, distinct from similar provisions in related laws. We do not see anything in the text of these statutes to indicate that Congress understood the public charge provision to be such a circumscribed outlier. Okay, first, you know how there are people who are going to argue that undocumented immigrants are bad because they're just coming here to live off the government at taxpayer expense? What the Fourth Circuit just cited undermines that argument. Undocumented aliens are not permitted to receive benefits like cash assistance programs. If someone has just snuck across the border, they're ineligible to receive these cash assistance programs. It's written in the law. But let's face it, these people are not arguing based on reason, because you can put the text of the statute right in front of them, and you can show them in black and white how undocumented aliens are not going to be eligible to receive government benefits, and they're still not going to believe you. And that's because their argument is based on racism and bigotry, not on reason. Now, that being said, the Fourth Circuit is essentially saying that Congress already bans these newly arrived immigrants from benefiting from cash assistance programs. And if they can't benefit from these programs, but Congress still includes the words public charge as a grounds of inadmissibility, then public charge has to mean something more than likely to rely on the government for cash assistance programs. And since Congress didn't define what that means, it's up to the executive branch to determine it. We recognize that the rule before us is controversial. As in all matters of controversy, there are passionate pros and cons. Our inquiry, however, concerns not the wisdom of the rule but its legality. As to that, the text and structure of the INA yield a clear answer. The term public charge is naturally read as meaning just that, somebody who produces a money charge upon the public for support or care, and the DHS rule comports with this reading. So this is where the conservative nature of the Fourth Circuit is coming out. The court doesn't want to interfere in the policy making of the executive branch. The court doesn't want to be seen as a judicial activist. This is the main difference between courts like the Fourth and the Fifth Circuits and, say, the Second, Third, or Ninth Circuits. Those courts are far more likely to intervene and tell the executive branch that what they're doing is bogus. This is why you can end up with different rules that apply in the different circuits. And from time to time, those rules will come to the Supreme Court in order to get it all settled once and for all. At any rate, the Fourth Circuit has rejected the argument that the term public charge has only one meaning. And now the court will turn to the second step in the Chevron analysis. Under Chevron, courts must uphold an agency interpretation as long as it is a permissible construction of the statute. As noted, the rule made two substantive changes to the 1999 field guidance that was previously in place. First, it replaced the primarily dependent standard with a more concrete metric defining public charge as an alien who receives one or more public benefit for more than 12 months in the aggregate within any 36-month period. Second, the DHS rule incorporated for the first time certain non-cash federal benefits as part of its definition of public benefit. These changes follow from a permissible construction of the INA. DHS's definition of public charge is clearly consistent, as mentioned, with at least an ordinary understanding of the term. Further, the rule facilitates the broader congressional policy goals contained in the INA and related immigration statutes. In particular, Congress's stated desire that aliens within the nation's borders not depend on public resources to meet their needs. Lastly, the DHS rule fits comfortably within the surrounding structure of the INA. For example, in addition to the sections noted above, the rule's decision to cover non-cash benefits is supported by the fact that another provision of the INA bars DHS from considering any benefits that an alien may have received as part of its public charge determination if an alien has been battered or subject to extreme cruelty in the United States. Congress's use of any here would be odd if DHS only were permitted to consider cash benefits in its analysis. All told, the text, purpose, and structure of the INA make clear that the DHS rule is premised on a permissible construction of the term public charge. To hold otherwise is a serious error in statutory interpretation. Most fundamentally, though, it is also a broadside against the separation of powers and the role of Article III courts. So the court administration is saying that the Trump administration's rule fits within the broad definition of public charge. Moreover, there's a congressional policy of not permitting aliens to rely on public funds for their needs. This new rule from the Trump administration is consistent with that policy. Also, there's a provision of the immigration law that deals with benefits for abused spouses. It's called the Violence Against Women Act, or VAWA. Now, don't get confused by the name because it can apply equally with respect to men or women who are the abused spouse. And yes, abuse of male spouses by their female or same-sex partners happens. Just because you're a man doesn't mean you cannot be a victim of abuse. At any rate, benefits pursuant to VAWA cannot consider whether the victim of abuse has had any government benefits. And the court here is saying that if Congress used the word any in one section of the law when talking about government benefits, but did not use that when talking about the public charge definition, then it can't be said that Congress foreclosed the consideration of receiving certain benefits from being a public charge just because they're not cash assistance programs. The separation of powers concerns underlying Chevron are at their zenith in the context of immigration, a field that the Constitution assigns to the political branches. The exercise of federal immigration power is a fundamental act of sovereignty vested preeminently in and shared by the political branches. Specifically, this fount of authority stems not alone from legislative power, but is inherent in the executive power to control the foreign affairs of the nation, such that when Congress prescribes a procedure concerning the admissibility of aliens, it is not dealing alone with a legislative power, but is also implementing an inherent executive power. When Congress chooses to delegate power to the executive in the domain of immigration, the second branch operates at the apex of its constitutional authority. The court is using the separation of powers argument to say that it doesn't want to intervene here. And some courts will rely on this. They'll say that the Constitution specifically grants this authority to one of the political branches, Congress or the executive. And so the courts, we really don't have a role in this particular matter. Now, my problem with the way that the Fourth Circuit is doing this is that they're leaning on this inherent authority of the executive branch to conduct relations with foreign powers. And this comes from a Supreme Court case from back in the 1930s or 1940s. The problem is that this line of thinking doesn't rely on the text of the Constitution. It relies on some idea of how international law and international relations works. The Constitution speaks directly on the issue of immigration policy. Article 1, Section 8 specifically grants Congress the authority to establish a uniform rule of naturalization. Naturalization is the rules on who gets to be a citizen, and the Congress specifically gives that to Congress to decide, not the executive. In fact, it's not really true that the executive branch has all of this grand inherent authority over international relations. Article 1, Section 8 gives Congress the authority to regulate commerce with foreign nations. It gives Congress the authority to determine the value of foreign currency. It gives Congress the authority to define and punish piracies and felonies committed on the high seas. That's international law. It allows Congress, it gives Congress the authority to define offenses against the law of nations, and that again is international law. It gives Congress the authority to declare war. Heck, the Senate has the authority to ratify treaties. So it's a complete misnomer and misapplication of law to say that the executive branch has all of this inherent authority over foreign relations and to give all this deference to the executive branch on immigration issues because of it. And opinions like this are dangerous because they contribute to this overaccumulation of power by the executive branch, which only leads to further corruption and possibly tyranny. Properly evaluated, the DH rule is unquestionably lawful. Congress has delegated to the executive the power to implement a purposefully undefined provision of law in an area where the executive possesses inherent constitutional powers and unique structural competencies. To whatever extent the federal courts are empowered to review how the executive discharges this duty, the separation of powers demands careful deference from the judiciary and intervention, if at all, only in truly exceptional circumstances. This is not one of them. We have no doubt that the public charge bar has been applied more narrowly in the past. After all, DHS engaged in an extensive notice and comment rulemaking to bring about the change in extant policy. But change in whatever direction is what Congress anticipated when it steadfastly refused to define or particularize the public charge provision. The only question before us is not whether DHS should have used its power in this fashion, but whether it could have. For the foregoing reasons, the answer to this question is clearly yes. Okay, I skipped over a bunch of stuff where the Fourth Circuit criticized a decision by the Seventh Circuit, and that's the circuit that includes Chicago, and criticized the dissenting opinion in this case. And that, for us advocates for immigrants, is our saving grace. Even within courts like the Fourth Circuit, there are judges who will see things from a different point of view. Sometimes when you have a very important issue and you get a very disappointing decision, you can ask for a rehearing en banc, which means a rehearing by the entire court. Now let me take a step back again and explain that circuit courts have a number of judges appointed to them. The Fourth Circuit has a total of 15 judges, and not all judges sit on all of the cases. Typically, in an appellate court, you're going to get 3 judge panels, which means that 3 out of the 15 judges are going to sit on one panel, and they may hear something like 5 cases. And then you'll have another panel of another 3 judges who will sit and hear a different set of 5 cases. When you're applying for a rehearing en banc, you're asking for a hearing where all 15 judges will be on the panel. All of the judges will then hear the case, and they will all vote on which way the case should be decided, with a majority needed in order to overturn the trial court's decision. Now, the plaintiffs here could ask for a hearing en banc, given how disparate the opinions of the different judges on this panel were on this decision. So, stay tuned. We'll see if there are any further developments, and we'll report back. Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.